morning.
Good morning.
Mr. Semenya.
Good morning, Chairperson and Commissioners. We have Dr. Jacobs today for any cross-examination.
Thank you. Dr. Jacobs, you are reminded that you are still under your former oath.
That's right.
Thank you. Mr. Vani.
As the Commission pleases. Firstly, the correct way to address you is it Dr. Jacobs or General Jacobs?
Whatever you prefer, but I'm not working anymore, so you can refer to me as Doctor if you want.
Dr. Jacobs, okay, thank you. I was going to stick with Doctor, but I thought I'd just check. Firstly, Doctor, thanks for making yourself available for the cross-examination this morning. We have provided you and your team and the commissioners with essentially most of our questions. We intend to stick to those questions. So the idea is not to take you by surprise and to allow you, we've given you the time to prepare as well. So I'm hoping that we can have a constructive exchange this morning. And I'm going to kick off, and perhaps I can draw your attention to the application to cross-examine you because the questions are set out there, and it might be easier to follow. So that is, I can draw your attention to page 2 of the cross-examination bundle. And perhaps let's start at paragraph 9. We would like to know whether you had any knowledge or involvement in the process that led to the development of the amendments to the prosecution policy, either in discussions, reviewing, or the drafting of those amendments.
Chairperson, I was not involved at all in that process. I learned about the the amended prosecution policy after I've been designated to attend the meetings of the ITT.
Meetings of the task team?
Task team, yes.
Yes. But you do have a sense of what the amendments, the content of the amendments and how they propose to treat the TRC cases?
That is correct. When I started in the task team, I got a copy of the amendments and I noted it.
Okay. Now, I understand that you have a Doctor of Laws as well as a second doctorate.
That's correct.
Can I ask you for your views of the guidelines and whether, in your considered opinion, the guidelines as they apply to the TRC cases were constitutional and proper, and perhaps to be fair, I'll put to you the view of the families, which is that it carved out a special regime just for the TRC cases, and in particular put up special criteria that could be considered for a decision not to prosecute, that only apply to the TRC cases and not others. So in the light of that, and as a very experienced lawyer and police officer, what's...
Chair, before the witness answers, really the opinion of this witness is irrelevant. That policy has been set aside. It's not there anymore.
Thank you. Mr. Vani.
Chair, it was set aside, but I believe only in 2008 or 2009. We're talking about the years while it was in operation, and while the witness was in the task team, it was in operation.
Yes. How will it assist us, Mr. Vani, at the end of the day?
Well, it might be interesting for the Commission to hear from somebody who was in the task team and who does possess a Doctor of Laws, what his view of the policy was in demarcating a separate regime for the TRC cases.
Yes, I will allow it to that limited extent.
As the Commission pleases.
Thank you, Chair. As I understand it, this policy was amended after a lot of interaction between a number of role players. And it went through a process where it was tabled in Parliament, it was tabled in Cabinet. Both Parliament and Cabinet have noted it. And if you look at the policy, it is determined by the National Director of Public Prosecutions and with the concurrence of the Minister of Justice. So it went through quite a huge legal process before it was actually then put in the Gazette. For me to question it, you know, if I look at the intellectual knowledge that's within the NPA and with all the prosecutors they have there, it is a prerogative of the NDPP to draft that. And I think for me as an official working in the police, to have any doubts about that or to think it might be unconstitutional, I don't think it was up to me to make that decision or to query it.
Okay, let's move on. And let's turn to paragraph 7, also on page 2 of the application. You've already indicated that you were assigned to the TRC task team, and that was on the 10th of October 2006. And this was by former Police Commissioner Jackie Selebi. Before we turn to the questions, would I be right in saying that the Commissioner Selebi, was he your direct boss? Did you report directly to him?
No, there was at that stage a Divisional Commissioner for Legal Services, Divisional Commissioner LTMP Mtumkulu. She was directly in charge, but I was dealing with operational matters, so I quite often related directly with like the Divisional Commissioner, Detective Service or other divisions. And that basically was the position. But I had to report at the end of the day on my general work to Commissioner Mtumkulu. In this case, I was designated by the National Commissioner, so I might report to him directly, but I will also keep my direct head in the loop.
Thank you. And while we're talking about Commissioner Selebi, he was not a career police officer, as I understand it. He was brought in to assume the post of commissioner, but he hadn't had a career in the police. Is that correct?
That is correct, yes. He had high-profile work in Geneva, and I think he was responsible for pushing through the adoption of the Convention Against Landmines. And so in that sense, I think, you know, I can't question anything about his appointment or his career or background, but he was not a career police officer. That's the short of it.
Yes, it seems that prior to his appointment, he was Director General in the Department of Foreign Affairs.
Correct.
And prior to that, he was South Africa's ambassador to the United Nations in Geneva. And then prior to that, he was a member of Parliament.
That's correct.
Were you aware that Commissioner Selebi was one of the ANC 37?
Chair, from the documentation, it was not that evident. But later on, and I must say, even when I went through these documents, I saw that in the application to the TRC by the ANC for amnesty, general amnesty in respect of everything that they have commanded to do. I saw his name was in there.
Yes. Commissioners, that amnesty application that Dr. Jacobs refers to is in bundle 3 at page 107. So let's then turn back to paragraph 7, and as you can see, we quote from the amended prosecution policy, paragraph B6. It says the PCLU shall be assisted in the execution of its duties by a senior designated official from following state departments or other components of the NPA. And so 4 departments are listed, including NEAR, Department of Justice, and the DSO. And then when it comes to SAPS, it says the Detective Division of the South African Police Service. So my question, Doctor, is you were not a detective, you weren't with the Detective Division, you were with Legal Services. Why did Commissioner Salebi appoint you and not somebody from the Detective Division?
Chairperson, when I started in the police service in 1995, I was appointed within the National Crime Investigation Service, the NCIS. And that was later changed when the Divisional Commissioner of Legal Services came into play. But if you would look at the annexure to my affidavit, the first main affidavit, you will see there was no reference in the invitation to the National Commissioner to designate. Only said designated persons from your department. So I am working in I was working in the Department of Police. I had very close contact with the Detective Service, but in respect of deciding who will attend, that was a decision by the National Commissioner, which I can't explain because that was simply his decision together with Assistant Commissioner Lakalakala, who was also designated.
But would you agree that it's an unusual choice because the amended policy B2 specifically said, specifically demarcated that it would be somebody from the Detective Division?
I can see that now, but at the time when you started off with that, then I haven't yet studied all these documents and things. And I must also add, through my career, I've worked very closely with the PCLU, with all the officers there. The same cases that they were investigated, I had been involved in some degree or other. The mercenary issues, even the nuclear issue, when we had to look at how to deal with the exhibits in that case. So I had a very close working relationship with the PCLU, and in addition, I have been exposed in the Detective Service environment. So that is basically what I can say. To me, it didn't really appear strange, because I would say now, I would have been quite happy if they sent someone from the Detective Service.
Yes. Well, it's just that not sending somebody from the Detective Division suggests that perhaps Commissioner Salebi, wanted them not directly involved. He wanted a layer between the Detective Services and the task team.
I would not say that, because if you take Commissioner Lakalakala, he was from Crime Intelligence, and Crime Intelligence and Detective Service work very closely together. As a matter of fact, with high-profile investigations, you will find that the Detective Service cannot really investigate the case if it's not in close cooperation with Crime Intelligence. So I think that covered part of your concern, but as I've said, the invitation did not limit the National Commissioner to a member of the Detective Service. And if you look at the policy itself, it said a designated official from the following state departments. And as a matter of fact, the Detective Service is not a state department. But This letter was addressed to the National Commissioner as the head of the South African Police Service, and he was asked to designate an official, and in brackets S, or officials, to serve on the task team.
And moving now to paragraph 6, when the Commissioner appointed you, did he give you a specific mandate? Was there perhaps a discussion or perhaps directions in writing?
Chairperson, no, not at all. If you look on the document, you will see that invitation, and is put here in paragraph 7 at the top as well, on 10 October I was designated. So, and the first meeting was on the 12th of October. So I was simply given the document and say, look, there's a request for designation. You and Assistant Commissioner Kala have been designated to attend the meeting. Do so.
All right, then let's move down to paragraph, or rather, can we jump to paragraph 12 on page 3? Now, if you look at 12.1, we make reference to the fact that, according to your evidence in chief, the minutes of the meetings were not shared with the Commissioner, but that you briefed the National Commissioner from time to time. In those meetings, did you discuss specific cases?
I briefed the National Commissioner and I kept him abreast of developments, but apart from the Chikane case, where the National Commissioner just simply said that his view is that the Reverend Chikane does not want a prosecution, and he didn't take it any further than that, just to state that that is his position as he understands it.
And did you discuss the general functioning of the task team?
Chairperson, the minutes of the task team were very limited. I mean, if you look at them, most of them are 1 or 2 pages. There might be one that's maybe 3 pages. But they were very brief, and the National Commissioner preferred to be briefed on it. And as a matter of fact, until the report that was submitted and the request from from Ms. Advocate Mahaga on investigations they want to have completed, there was actually not really anything substantive in the minutes to bring to the attention of the National Commissioner. But I would brief him on, in generally, what happened at the meetings.
Okay, then perhaps we can return to paragraph 10. And you will recall that at some point in the deliberations of the task team, this is now towards the end of 2006, early 2007, matters came to a head, certainly around the interpretation of the guidelines. And as we set out here, Commissioner Salebi took the view, supported by National Intelligence Agency, that a recommendation from the task team and the Directors General was necessary before the NDPP could make a decision in each TRC case. And as you're aware, NDPP Pakuli objected to this, complaining that that was an unwarranted interference in the work of the NPA. Do you accept that that requirement, that the NPA had to wait for a recommendation before it made a decision in each TRC case, that amounted to a clear and unwarranted interference in the work of the NPA to conduct its own prosecutions?
Chairperson, I do not agree with that. It seems to me there's something wrong with this mic. The light is not on, but if you can hear me, it's fine. Thanks. Firstly, I must say, if you look at that view, even in the first meeting of the task team, it was pointed out, it was PCJ2 in the Jacobs bundle. It was pointed out that the role of the committee will be to make recommendations to the NDPP on each case. Now, that in itself says that the NDPP is open to recommendations. If I look at the administrative law in general, the requirement for any person taking a decision is to take all relevant factors into account. And if there were concerns from the departments, and there was a reason why those departments were in there, the intelligence agency, for example, to guide in terms of intelligence concerns, etc., detective service to assist with investigations. So, for the directors general, whether it is as a collective or whether separately through their representatives, the issue about collective was mentioned in the letter from the National Commissioner. Whether it's one of the two, in my view, does not interfere anyway with the powers of the NDPP to be the final decision maker. And even in his letter to Advocate Piccoli, that is PCJ 13 on page 1756, you will see that that was the understanding of the National Commission. He said, my understanding was that the officials designated on the task team by the Directors General will provide recommendations to the Directors General, who will as a collective advise the National Prosecuting Authority as the decision maker on prosecutions. In other words, he never denied or interfered in the sense that, that he thought he can change the decision. And for the National Director to listen to concerns, I mean, in terms of the guidelines, the victim need to be consulted. It is said there that any other state department could be involved in terms of gathering information. So the whole issue of making recommendations to the National Director really does not interfere with his powers. And if there was a concern about delays, if, for instance, a recommendation is asked from the Directors General and they would delay, then from scratch, the NDPP can lay down a time frame and say, give your input within a week or 2 weeks, and then I'm going to make my decision. And when that 2 weeks have expired, nothing stops him from making that decision, and he can't be queried on it because he's the final decision maker on prosecutions.
Yes, it's certainly not, the issue isn't receiving recommendations and support or advice. It's what Commissioner Salebi sets out, that the Directors General, and I'm looking at the third paragraph of PCJ 13, the Directors General must provide the input before a decision of prosecution is made, and that is repeated on the next page, second paragraph, that the DGs must discuss the matter before a decision was made. So in other words, what NDP Piccoli was objecting to was the clear intention behind what Mr. Salebi was saying, as supported by DOJ as well as NIA, that effectively he couldn't act until he received a recommendation. And that's the objection. And the rejoinder that he could have laid down deadlines is not an answer, because saying that your hands are tied until you hear from us is the objectionable part of it.
But that was not the end of the story, Chair. you will see that the National Commission requested the NDPP to convene as soon as possible a meeting with the Directors General in order to discuss the above matters. And if you would look at the top paragraph there on page 1757, you will see that, in my view, a comprehensive report such as the one directed to the NPA should be discussed by the Directors General. These were views expressed with an invitation to have a meeting with the NDPP and the other Directors General to come on the same page. But that meeting did not take place. Just a day after this letter, the NDPP said that he will take the matter to the Minister of Justice.
So let's move on. Let's now turn to paragraph 13 on page 3 of the application. And we want to inquire from you, Doctor, whether you were aware of the overriding concern of government at that time, namely that prosecution of former apartheid officials, such as the suspects in the Chikani case, would give rise to a call or pressure for prosecution of ANC personnel for their activities pre-1994.
Chairperson, I was not aware of that. To some extent, these issues have been mentioned by Advocate Ackerman in his report, where he complained about using Senior Superintendent Brits to assist the police regarding the documentation. And that was basically then in that complaint by Advocate Ackerman, it was put that all the issues they had against Brits, and there was also mentioned that the issue about the prosecution of the ANC 37 was raised in the highest level of government, and that was to not the President, but the Presidency, and also with the Minister of Justice. And that there was then interaction between the Minister of Justice and also between and the NDPP's office, and also with the Department of Justice, if I remember correctly, Minister Penel Maduna, and they were all satisfied that there was no such investigation. So that broad statement that there was such a general fear on a political level was not, in my view, portrayed by what happened at that meeting.
All right, let's turn to a document where this issue is highlighted. And this was a document that, in fact, was only brought to our attention after we had submitted your application. It was uncovered by our colleagues in the Commission. And if you can turn to page 25 of the cross bundle, and there you can see this is, I'll just wait for you to get to page 25.
That's correct.
So this is a secret internal memorandum addressed to the then Minister for Justice. It's from the acting NDPP. It's titled Management of TRC Cases by the NPA, and it's dated 14 December 2004. So I think we'll spend a little bit of time going through this document because it sets out the perspective of the NPA. So if we look, for example, at paragraph 1, the purpose of memorandum, it said the purpose of the memorandum is to respond to allegations made at a meeting with certain cabinet ministers and the National Commission of the Police Service regarding the management of TRC cases by the NPA and to dispel any other misconceptions. So it doesn't give the date of that meeting, but presumably it would have been towards the end of 2004. And at that meeting, the National Commissioner made various allegations. Are you aware of such a meeting?
I'm not aware of such a meeting.
Thank you. And if we can turn the page to the second heading, number 2, historical background. We won't go through everything here, it'll take too long, but I think you're probably familiar with the fact that the investigations after the winding up of the Goldstone Commission and the De Oliveira investigation was divided into 2 teams, one looking at offences by the security force members, and then a second team looking at the liberation movements and the right wing. And that this last team was comprised of Director Nell and Senior Superintendent Brits of SAPS, and they worked under Deputy Attorney General Paul Fick. Now, it appears from paragraph 2.6 onwards that these 2 police officers, Nell and Brits, continue to work on these cases. Their contracts were routinely extended by SAPS. And even with the creation of the DSO, when the cases were transferred to the DSO, Advocate Fick continued with those cases, assisted by the same 2 police officers. And then if we turn the page, just to wrap up that story, we see that the PCLU was created in 2003, but that it wasn't an investigative agency. It would have to be dependent on SAPS and the DSO to assist with the investigations. Is that roughly also your recollection of that history?
That is correct, yeah. But if you look at paragraph 2.10, you will see that the PCLU was not an investigative agency, and therefore it was dependent on SAPS and the DSO to assist with investigations.
Yes, indeed. So then if we move to the next heading, management of TRC cases by the PCLU in March 2003, we see at 3.3 that the PCLU did an audit of cases, including the cases with Advocate Fick, and there were about 395 police dockets. Various annexes were attached. Unfortunately, we don't have those annexes. We have asked for them. But those lists indicate which cases were closed and which were still open. But let's turn to page 4, and then matters arising. And here, an account is given of the meetings with Commissioner De Beer, the fact that assistance was sought in relation to certain high-profile cases in 4.12. There's 7 cases, including PEPCO 3, Craddock 4, Victoria Mchenga, and others. And in 4.13, it set out that in September of that year, Commissioner De Beer said that, having discussed the matter with the National Commissioner, without the express instruction of the President, these matters wouldn't be investigated because those cases were all the suspects were ex-policemen. Is it also your recollection of what transpired?
Look, I've seen the letter from that Commissioner De Beer wrote. I think the wording here is a bit brief in terms of what is actually in the letter. What was said in the letter, as I've read it, is that the understanding was that the DSO will investigate these cases. And it was referred to that this was possibly a political decision, but that issue about the political decision was explained just in the next sentence, where it was said that many of the people who will be prosecuted might be police officers. And the fact is that there might be distrust against the police to perform that function.
But is it not quite routine for SAPS to investigate police officers who've committed crimes? Perhaps not using police officers from the same section, but elsewhere within the force. Doesn't that happen on a fairly routine basis?
Let's take the senior sub Brits thing. The suspicions that were there from even from the NPA side on an ex-security police officer investigating these cases and being further involved with the ITT or with the police service.
Yes. Although that was an objection to a specific police officer because of his specific background, as opposed to a general objection to the police investigating other police.
That's correct.
Yeah. Then the acting NDPP writes in 414, the perception unfortunately created by this decision is that SAPS was only interested in targeting members of the liberation movement.
That is a perception of from the NDPP side. I can't comment on
Yes, no, I want your reaction to the view of the acting NDPP.
Yeah.
Is it a fair comment or not?
that. I don't think it's a fair comment. I don't think it's a fair comment.
All right, then let's look at the next section dealing with the ANC 37 case. And the point is made that the TRC refused amnesty to 37 prominent leaders of the ANC, including the President, Mr. Thabo Mbeki. And at 4.2.2, members of the PCLU held discussions with Nel and Brits, during which discussions Nel and Brits persisted that there was a strong case against the President and other prominent cabinet ministers. And the next sentence is the key one. This was raised in the context of attempting to persuade the PCLU not to prosecute security branch members on the basis that if such members were prosecuted, the President would have to be prosecuted as well. So this is the acting NDPP saying that from the discussions the NPA had with Nel and Brits, this is the message they were getting.
Chairperson, I think I must make it clear at this stage that Nel and Brits were police officers. They were given to the De Oliveira task team and then transferred to the office of the NPA to assist people further with the investigations. What they communicated cannot be regarded as communications from SAPS, because that was done on their level. It was not communications from SAPS. If they did this, it might have been in terms of their own experience, and I can't further comment on that.
Yes. Well, that's fair enough, except that that view was also expressed not by individual police officers, but also a few years later at a meeting of I believe it was the Justice and Security Cluster, and the following was said by Minister Squeyiya, and this is at bundle 2, page 142, paragraph 274.2. And I'll just get my team to extract it, because I don't think it is part of this bundle. Oh, I'm told that it actually is part of this bundle at page 351. Perhaps we can just jump there.
Yes, I'm there, thanks.
So this is the supporting affidavit of of Vusi Pekoli. It is 2015 affidavit. And if one turns to paragraph 13, or sorry, page 13, which is under paragraph 33. And here, Pekoli is relying on his affidavit before the Ginwala Commission, and he quotes from that affidavit. And at the top of page 351, the Minister of Social Development was concerned about the impact of the decision to prosecute on the ranks of ANC cadres, who were worried that a decision to prosecute in the Chakani matter would then give rise to a call for prosecution of the ANC cadres themselves, arising out of their activities pre-1994. So this wasn't just a view of individual police officers, but it had found its way to the cluster, and it was a view expressed by a minister at one of those meetings.
Chairperson, if I can comment on that, I was not part of any of the meetings referred to in paragraph 211 to paragraph 218 of the founding affidavit of Mr. Kalata. I was not part to any of those meetings, so it's not within my knowledge that this has happened. I've read the documents and seen it, but it was not part of my experience with this issue.
Thank you. All right, then let's return to the secret internal memo, the 14 December 2004 memo from the acting NDPP to the minister.
Page number?
On page 29.
Thank you.
And you'll see that the report continues in relation to the investigations of Brits into the ANC. And he points out in 4.2.5 that the docket or the dossier was with the former National Commissioner Johan van der Merwe, and that requests were made for that dossier or any docket that was in the possession of Brits, which was never produced. Do you have a recollection of that?
I have not been involved at all with that.
And then at 4.2.6, the PCLU was then informed by the NDPP that Commissioner Salebi had alleged that the NDPP and the PCLU advocates were on the verge of arresting the president.
No, I have no recollection. As I've pointed out already, some of these points have been dealt with in the report of Advocate Ackerman. You'll see there the consequent visit by Minister Maduna, etc.
Yes. Now, the reason why we're going through it is that notwithstanding the denials of Ackerman, these allegations continued from 2003 through 2004, and were still surfacing in 2006. So the report continues that steps were taken. Minister Maduna in 4.27 visited the offices of the NDPP to look into these allegations. 4.28, the PCLU perused all available evidence and concluded that there was no evidence against the president. 4.29, to clear the lines, the NDPP directed that Brits and Nel vacate the offices of the DPP and that all their dockets be returned to SAPS. Brits, in fact, was reinstated in SAPS, Crimes Against the State. But nonetheless, he still contacted the deputy head of the PCLU, that's at 4.2.11, wanting written confirmation of the decision not to prosecute the president. That was on 2nd July 2004. And then just a few days later, on 5 July 2004, he and his unit commander approached the deputy head of the PCLU complaining about the decision not to prosecuting, alleging there was an abundance of evidence. Were you aware of any of those developments?
No, not at the time.
But if we accept what the acting NDPP is saying here, would you agree that the push for cases against the ANC was in fact coming from SAPS, or at least those particular police officers within SAPS, rather than the NPA?
Yeah, also doing this in their personal capacity and not on a level that's on a policy level.
Well, I wouldn't say it's their personal capacity. For example, if you look at 4212, on 5 July 2004, Brits and his unit commander approached the deputy head of the PCLU complaining about the decision not to prosecute. That wouldn't be in his personal capacity.
No, I agree as a police officer, but what I'm saying was not on a policy level, it was on an operational level.
Only the acting NDPP who drafted this document on the 14th December 2004, was that Advocate Mokotedi Mti, or who was it?
No, Commissioner. We believe it was Advocate Silas Ramaita. SC.
Oh, Silas Ramai.
Yes.
Oh, yes. Okay. Thank you.
All right, then let's return to the application to cross-examine, page 4. And here we're now dealing with the SAPS audit reports that were presented at the TRC task team. Now, just by way of context, in paragraph 14, we point out that in your evidence in chief, you indicated that you weren't hands-on with these cases, but you sought the services of Senior Superintendent Henry Brits to compile the SAPS report. And after he was requested to do so, after you were requested to do so at the TRC task team of 12th October 2006, and that's at PCJ 3 of your statement. You then made an oral presentation of those cases at the task team meeting on the 25th of October 2006.
Yeah. Chairperson, if I can comment on that.
Yes.
What happened is that I requested Senior Sup Louis Bester to provide me with a list that was of the cases within that the police had. He provided me with a list, and that list was taken to the that meeting of the. It was on the meeting of the 25th of October, and I do not have a copy of that list. And also I don't know exactly which names were on the list, but I suppose it was a broad list of the dockets that the police had. But I don't know exactly how that list looked like, and I talked to it, and that is why I said there was not a written, it's an oral presentation that was done.
Thanks for that, Doctor. So it was in fact Senior Superintendent Bester, not Brits, who.
Senior Superintendent Bester, yes. I never worked with Senior Superintendent Brits. He has already left the police service when I started interacting with Louis Bester on these matters.
Noted, thank you. All right, so then the questions we have about differences between the lists, you wouldn't be able to help us because you didn't see the original list.
That's correct. All
right, then let's turn to the the next page, paragraph 17 on page 5 of the application to cross. You state in your evidence in chief that you received copies of 73 decisions that were taken by Advocate Ackerman SC on various dockets from Senior Superintendent Bester, and that these decisions were used by you to compile the SAPS audit report that was presented at the 6 November 2006 meeting, but that you didn't receive the actual dockets from Bester, just copies of the decisions. Is that an accurate reflection?
I did use the decisions in the file that I received from Louis Bester of the 37 decisions that were taken. But I also requested Senior Sup Louis Bester to provide me with a list of the outstanding matters in that file. And he pointed me to some of the outstanding matters, which were the matters that I've dealt with in the report, and which were also actually including those relating to quite a number of inquests. And I did not receive the actual dockets. I think if you look at 395 dockets, to expect in this period of time that was even available between the two meetings, it would have been impossible to do that. But I also didn't really have a need for that. Senior Superintendent was an experienced detective, and we were looking at that stage at the outstanding matters. Because you will recall in that report of Advocate Ackerman, at the meeting of 25 October, Advocate Ackerman clearly indicated that these files, these dockets, were transferred to the police service because it's the property of the police service, and then also, and the NPA has no further interest in them. The police may come back if they want prosecutions in certain cases, like maybe the Blani case or whatever, although the Blani was before that. I think that it should be seen in that, within that context.
Thank you. So, not all 73 decisions were reflected in the SAPS report, the audit report that you presented on 6 November 2006.
No, because we referred to the outstanding matters in that file.
Okay. All right, let's then turn to paragraph 19. In your evidence in chief, you stated that the cases reflected in the SAPS audit report at the 6 November 2006 meeting were cases in which SAPS sought clarity from the PCLU regarding the holding of inquests. Were these the outstanding cases you have just mentioned?
That is correct, Chair. That is on PCJ 8, page 1743.
Thank you. Chair, we're about to deal with a new section dealing with a number of possible inquest matters. Before we dive into that, would this be an appropriate time for the tea adjournment?
Yes. We'll adjourn and reconvene at 11:15.
Will the chair please accept?
Mr. Vani.
As the chairperson pleases. Dr. Jacobs, just before tea time, we had reached paragraph 19, page 5 of the application to cross. And as you can see from paragraph 19, we seek clarity on the SAPS audit report that was handed up by yourself at the 6 November 2006 meeting of the task team. The minutes of that meeting are at PCJ 6, page 1735 of your bundle. Although in fact, the audit report was not discussed at that meeting, but at the next meeting, which was held on the 16th of November 2006. And that's at PCJ 9, page 1750 of your bundle. And perhaps let's turn to PCJ 9 at page 1750 of your bundle, because we just want to put to you the objections of Anton Ackerman to the putting up of your audit report. And as you can see from the 4th paragraph, and I'll just read that first sentence into the record. Advocate Ackerman raised a concern over the impression created by the revised audit report from SAPS, that he had indicated his intentions of exploring the possibility of prosecuting the President and 37 ANC leaders. Advocate Ackerman wanted to know from Commissioner Jacobs, who compiled the report, why it was necessary to include cases that had been finalized and request inquests on such matters. So it does seem as if the 7 cases in question did deal with matters in which landmines and other events had taken place. Before we go through the cases, can you remind us your response at that meeting to Advocate Ackerman's concerns?
That is, Commissioner Jacobs indicated that he compiled the report and requested guidance from the meeting on how to deal with outstanding inquests. He said they had 6 inquests, some had been finalized and others not done at all, and that were all TRC matters.
Thank you. All right, then let's turn to those cases. Although before we do, can I just draw your attention to an information note that had been compiled for you by Commander Crimes Against the State, Senior Superintendent Bester, and that's at page 1574 of your bundle, and it looks like it's also in the cross bundle at page 37. It might be easier just to stay in the cross bundle and go to page 37.
Thank you, I have it.
And you'll see it's an information note. It's addressed to you, titled TRC Related Matters Inquest. And there are 8 matters there. And with the exception of number 8, they're the same matters that are listed in your audit report. Did you rely on this information note when you compiled the SAPS audit report?
Chairperson, I think there's a lot of context that need to be given to this document, this information note from Senior Superintendent Louis Bester. And maybe if I'm wrong in my answer, I think the views that I will express and the concerns is that if I address that context, I think all these other matters will actually be clear to you as well. So if I can ask that we also look at the same time at the audit report, PCJ 8, which is on page 1743 of the Jacobs bundle. Thank you.
Yes. Please proceed.
Chairperson, as I've already mentioned, I asked Superintendent Louis Bester to indicate to me which matters are outstanding, and he referred me to these cases. I then drafted the report based on that, and you will see from the report all the paragraphs there is actually giving the gist of what every case is about. Because if you just give a name of a case, etc., the other members on the committee won't be au fait, or they won't be know what you'll be talking about. Then after this, the meeting we had, and the concerns expressed by Advocate Ackerman, that these matters have all been finalized. You will see on top of that page, PCJ 81743, I wrote in my handwriting,
is that in all these matters, inquests, well, either criminal cases had happened and had concluded, as in the first case, and that's at 19.2.2.1. And if you look at the next 3 cases, inquests have been held in earlier years. In the second case, the Ellis Russ matter, the inquests were held in 1989. In the Kings Williamstown matter, Ackerman had directed an inquest in August of 2003, and it was held in February of 2004. And the fourth matter, the Deep Kloof one, that inquest was held as far back as 1994. In the fifth matter, he decided in 2003 to establish whether an inquest had been held in that matter. In the sixth matter, the Jeppe docket inquests were held in the late 1980s, and in the last one, an inquest couldn't be held because nobody had died in that particular event. So his concern, I think with some justification, is that there was no need to put up these particular matters before the task team, because there was nothing further to do in those matters. And he takes the view that it was put up to bolster this narrative that he and the NPA were still seized with those cases.
I deny that narrative, because as I've said, in terms of the timelines, that narrative does not agree with what I've just explained to the Commission. Because the information that Advocate Ackerman is giving there in respect of these things relate to the information note of Louis Bester. And Louis Bester gave that information note to me after I've presented the audit report.
All right, I'm sure the version of Ackerman will be that that information was in the records already, given the old dates of most of these inquests. But let's move on. Let's turn to the appointment of investigators for the TRC cases. If I can draw your attention to page 7, paragraph 20. And you'll see from that paragraph that in December of 2006, you sent a courtesy request to SAPS Divisional Commissioner, Detective Service General De Beer, to arrange investigators by provincial commissioners for 8 TRC cases. And you made this request by way of an undated confidential information note and that's at PCJ 17, and it's in your bundle from page 1763. Perhaps if we can just get that.
Thank you, I have it.
Now, did Commissioner De Beer ever respond to this information note? And if so, what was his response? Because we don't see it in your bundle.
Chairperson, thank you, but maybe I must just refer to paragraph 20 there on page 7. I do not think this was a courtesy request. The description of an undated confidential information note is correct, but it was a recommendation to Commissioner De Beer to appoint investigators, and the request was as well that the particulars of these investigators must be conveyed to Advocate Maga of the PCLU. The response of General De Beer, immediately when he received my information note, he requested me to draft the following document that's in my bundle, and that is the letter to the provincial commissioners. Now, if you would refer to that as a courtesy request, it might be more correct, because the national head of detective service, he is in charge overall of detectives. But with the provinces we have, you have certain detectives that serve directly under the provincial commissioners. So he had head office components and then provincial detectives. So it would just be a courtesy to ask or inform the provincial commissioners that investigators are needed. And normally, if there are problems to do it, then normally it's being sorted out between the provincial commissioner and the head of the detective service. So the response of General De Beer was to ask me to draft that letter that is then in PCJ 17, page 1763 of the Jacobs bundle.
Thanks. And in fact, that note to the provincial commissioners, you addressed that on the 6th of December 2006 at PCJ 18, and that's at bundle page 1766 of your bundle.
That is correct, Chair.
And as I hear your evidence, you prepared this letter on behalf of Commissioner De Beer.
That is correct.
Yeah. And the officers identified in paragraph 2, that's Superintendents Boshoff, Barkhuizen, Notladi, Zeeman, and Olafia. Who selected those officers?
Chairperson, if we could page back to page 1764, the Jacobs bundle, you will see this meeting actually followed, and it is set in the information note. A discussion was held with Advocate Ntunzi Maga of the Priority Crimes Litigation Unit, who is also on the committee, in order to obtain guidance on where investigators are needed. So I received on the meeting of the 22nd of November, I had a meeting with 2006, I had a meeting with Advocate Maga. He presented this list of cases where they need investigators, and you will see in that note, in 1 or 2 cases, they identified specific police officers. But before I finalized that, or I made that, or drafted the letter for Commissioner De Beer's signature, there was some interaction in detective service. I don't know exactly who, but there was some interaction to the provincial level to look at the availability of police officers. So in some cases, there was no specific request from Advocate Maga for specific investigators. You will see in respect of, if you look at paragraph 4.2, they asked for Fani Els from Port Elizabeth to assist. I expect that in the discussions between the detectives at head office and provincial level, they then decided on Superintendent Boshoff. You will see on page 1766. Barkhuisen, just the following one, was one of the names that Advocate Maga has indicated. So that is where that is how the names were identified of the investigators.
Thank you. So you mentioned that at the operational level you wouldn't necessarily be in that loop.
No, because it's an operational matter, as you say.
Yeah. Although at the TRC task meeting, I will direct you to paragraph 22, that meeting was on the 29th of January 2007, which turned out to be the last task team meeting held. And that's at PCJ 18 at page 1752. You reported to the meeting that feedback was being awaited from the provincial commissioners on the appointment of investigators, and that some had already provided their lists in that respect. So at least by the end of 2007, you were awaiting a response from those provincial commissioners. And yes, I understand that you weren't at the operational level, but given that you had made that report at the end of January, did Commissioner De Beer or those provincial commissioners ever come back to you to confirm that they had been appointed and they had commenced work?
I was, as a matter of fact, the line of communication would be from the provincial commissioner's office to the divisional commissioner. But the divisional commissioner did give some of the responses. They sent it from his office, they sent it through to me. So that is why I knew at that stage there were some investigators that have been made available.
Although you didn't know how many and in respect of which provinces?
I can't remember. I don't have that documentation at my disposal.
And perhaps I'm pushing my luck here, but of the ones that were appointed, do you know if investigations commenced?
I do not know.
All right, then it would be unfair to ask you for reasons why they didn't commence, so I won't put that question to you. So if we go down to paragraph 23, we want to put it to you that we can't find any evidence and record that those 8 investigations proceeded. And in fact, when Advocate Maga testified before this commission, he made statements such as the following, that the cases were never investigated by the SAPS. He served on the TRC task team, this is at 23.1, but there was never a dedicated investigative capacity that was allocated or assigned to the cases that I handled. And that's in the Maga transcript at page 70. It's actually in the cross bundle at page 149. Now, as far as we know, all these 8 cases remain unresolved till today. That's some 20 years later. There have been some recent developments, and we've actually pointed out some of those developments in the footnote. But perhaps let's start with what Advocate Maga has to say, that as far as he's aware, and at least the cases that he was handling, SAPS never allocated investigators to them.
Chairperson, I accept that the evidence of Advocate Maga relates to the term whilst he was still serving in the PCLU. In respect of my position, the last meeting of the the task team that I attended was on the 29th of January. So I don't know which cases might have been finalized, which were investigated, all that. I don't know.
Okay. Well, just to complete that, we've looked at those cases, and just to give you a sense as to what has happened since the end of 2006, early 2007, in Craddock 4, the reopened inquest only commenced in 2025, and that's still ongoing this year. In PEPCO 3, the prosecution was never reinstated, and the reopened inquest is only going to commence in October of this year. There's only one surviving suspect in that matter. In State versus Kritsia, an indictment was issued, but that was some 9 years later, in 2016, following an application brought by Tembi Simelane in 2015. That case is still ongoing. In State versus Henti Buerta and others, the accused were only charged in 2024. In COSAS 4, 2 surviving accused were charged in August 2021. That's also ongoing. In the Heidelberg and St. James attacks, the investigations into Mhlahlele, they remain unknown and unresolved. In the Ndondo case, there was a charge against a former security branch officer in November 2025. And then Mos Marudu, there was a symbolic burial in 2013, and there might be an inquest at a future date. So, in respect of those 8 cases that had been highlighted, one can see that action was only taken many years later, as recently as just the last few years. So I think we can assume that at that time, those investigations were not taken forward.
I do not deny that, Chairperson. That speaks for itself.
Yes. And we also attached a presentation that the DPCI head had made to the Portfolio Committee in 2025. I'm not going to go to it because you won't have knowledge. But we looked at those 8 cases, and the DPCI only opened their investigations about 10 to 15 years after these developments in 2007. But let's move on. So the next heading is the collapse of the task team on page 10. So we've already dealt with the differences that emerged between Commissioner Salebi and NDPP Pikoli, so we won't traverse that again. We know that Pikoli escalated the matter to the Minister of Justice. We don't have to deal with that. I can draw your attention to 26.3. The NPA sent an invitation to the NPA to attend a task team meeting for the 13th of March 2008. Then acting National Police Commissioner Timothy Williams stated that until such time that the matter had been cleared up, I'm of the view that the committee cannot function meaningfully, and he refused to participate until such time that the matter was resolved. He's instructed the representatives of the SAPS not to attend meetings of the task team, and of course the matter being whether the NPA had to wait for a recommendation before acting. Is that summing up in 26.3? Do you recall that response from Acting Commissioner Williams?
That's correct. I recall it. It was in May 2008.
Thank you. So we want to put it to you that since that matter couldn't be resolved because the NPA wouldn't agree to having its hands tied, and indeed it went ahead with the Chikani case without waiting to hear from the DGs. Because of that, SAPS not only withdrew from the task team, but persisted in withholding investigative support for the TRC cases going forward. And that this explains why the Chikani case went ahead, which had been previously investigated, and there wasn't a single prosecution or inquest that proceeded for the next 9 years. Your response?
Look, firstly, I want to state that I'm not aware that after 29 January that the police withdrew from the task team. The response from the national director was that he will interact with the minister. Now that issue had not been resolved, and the PCLU, who were the conveners of the task team, never called for a meeting of the task team. It is said here that somewhere I think in August there would have been one. I'm not aware of that one. I haven't seen invitation or minutes or something from that meeting. So in my view, the PCLU themselves and the NPA, they stopped the activities of the task team. If they would have invited us to come there, it might be that there could have been some discussions or whatever, but there was no further meetings of the task team convened by the PCLU.
Well, at least one invite was extended. We're trying to find the invite.
There was an invite for a meeting on the 13th of March 2009, I think.
2008.
8.
And in fact, that's the one we're referring to. So if we look at page 1808 of your bundle,
Yeah.
The Annex SA1, it says the representatives of the SAPS received an invitation for a meeting of the above-mentioned task team scheduled for 13 March 2008. And the rest we've dealt with. The Acting Commissioner Williams explains why they wouldn't attend. So you accept that there was an invite from NPA to a task team?
Yes. But not in the period between the 29th of January and the Chikani, the prosecution in the Chikani matter. There were no invitations for meetings.
Yes, I think that is correct. It seems that there was an attempt to resuscitate the task team in March of 2008.
Correct.
And I'm also right in saying that in fact it was never resuscitated. That January meeting of 2007, that in fact was the last meeting of that task team.
Okay.
And in response to what we put to you under paragraph 26.4, did I hear your response correctly that you have no knowledge of these matters post?
No, I've not been involved in, after the letter that was sent by Commissioner Williams, Acting National Commissioner, that until that matter has been resolved. And I'm not aware that whether the matter has been resolved or not, or what followed after that.
Yes. Well, it does seem that, well, we of course don't know if the matter was resolved, but we do know that later in 2007, Advocate Bakoli was suspended and Advocate Ackerman was relieved of his duties in relation to the TRC cases. But what we put to you that post that time, at least post the Chikani case, we're putting it to you that the SAPS withheld investigative support for the TRC cases, and that's reflected in the fact that very little happened post the Chakani case?
No, I cannot comment on that. It's it could be the experience at the side of the NPA, but I was not involved in stopping anything or blocking anything or
Yes.
preventing investigators.
And we're not accusing you of personally stopping anything.
Okay.
All right, then let's turn to the forged memorandum of 26 June 2003. And this is from paragraph 27 onwards. Now, in your evidence in chief, I understand that you took the view that the memorandum in question, which is sometimes referred to as A15, it's at PCJ 22, page 1774, but it's also annexed as Annex B to this application to cross. Is it still your evidence that that memorandum was not a forged document?
Chairperson, I conveyed to the Commission the two forensic analyses that have been done in this respect. I'm not a fingerprint expert or a disputed document expert or whatever, but those were the two reports that were given by people who are qualified to do that analysis.
All right, so I assume that you rely on those two reports and that your evidence is still that the document in question was not forged.
I did not give the instruction to have the analysis done, and the analysis was done with in determining whether the document is forged or not, but I cannot comment further on that in that regard.
All right, let's then turn to paragraph 28.1 on page 11. Now, where did you source this this document? This is the document, of course, we've highlighted. It's at Annex B, and it's the same document that you faxed to Advocate Ackerman on the 20th of August 2007, following the publishing of the article in the report on the 19th of August, the day before. That's at PCJ 20, page 1769. So where did you get the document that you faxed to Ackerman?
Chairperson, it was part of the document bundle or the file that I received from Senior Superintendent Louis Bester, and it was a document A15, which related to the landmine cases.
Okay. So effectively the source was Superintendent Louis Bester. Now we want to know why SAPS would be in possession of a document of that nature. And as you can see at 28.2, we say that if it was just a file note in the case docket, we can understand why Louis Bester would have access to it. But this document purports to be a memo addressed from the head of the PCLU to the Deputy NDPP. So why would SAPS be in possession of an internal NPA memo?
Chairperson, this file with the documents A1 to A73 was given to me as part of the documents that was transferred to the police service in 2004. It was part of that bundle. And there was a number, I think from A1, I read here, from A1 to I think 16, are in the same format as that. I would not question the manner and the type of communication that is being used by the PCLU. And the documents were photocopies of the file that Louis Bester had. The ones that I had. I didn't have the originals.
Right. Although it does seem that Louis Bester was in possession of the original, but we'll come to that shortly. Now, Ackerman denies that he would have addressed a memo in Afrikaans to Ramaite, SC, who's not a native Afrikaans speaker. Wouldn't that have raised a suspicion?
Chairperson, I do not know how Advocate Ackerman and Dr. Ramaite communicated with each other and in which language. I really won't know that. It wouldn't have raised suspicion with me. These documents were given to me. I must say, when I received the call from Advocate Ackerman to send him the copy of the document, I simply did that. And when he came back and said to me that, did I look at the date? I must say I was surprised, because I didn't have any suspicion about anything like that that could be at play.
Yes. Well, it is the evidence of Ackerman that when he communicated with Advocate Ramaite, it was in English, not Afrikaans. Now, when Advocate Ackerman called you and drew your attention to the date, and presumably, Ackerman was saying that the date is wrong, did that raise any alarms with you?
Look, I'm not, as I've said, I'm not a police officer, I'm not an analyst. To me, just the following day, there was this media statement by the NPA to say that the document is alleged to be a forgery. That was sent to Advocate Ackerman. That was on the 21st. Immediately thereafter, Commissioner De Beer and myself went and we informed the National Commissioner about this investigation into alleged forged document, disputed document. So then Commissioner De Beer requested Louis Brits to come to the office of the National Commissioner and to bring the file with the original document.
Can we just check, Louis Brits or Louis
Louis
Bester?
Bester, sorry, I'm just losing it there. But Louis Bester brought the file to the National Commissioner. If I remember, it was late afternoon. And then the National Commissioner, or the Commissioner De Beer, instructed Louis Bester to obtain a forensic analysis. So that was on the 21st. On the 22nd of August, Louis Bester took the request for a forensic analysis to the head of the Forensic Science Laboratory with an information note asking for the analysis to be done. And later that day, they received the analysis that was done by it was a senior superintendent, De Tooy as well. The other one was a divisional commissioner. This one was the analyst. So then that document was given, I believe, to General Solebi immediately after it was received. That was on the 22nd of August. So what happened is, just after that, Commissioner De Beer also asked Louis Bester to obtain an independent analysis. So on the 30th, and of course, because it's with an independent analysis outside the police service, financial authorization had to be obtained. So it took a short while for financial authorization, and on the 30th of August, 2007, the request to ex-Brigadier Hatting was given to do the forensic analysis. And he delivered his report on the 31st of August 2007. Then thereafter, and maybe I must just say that there was communication between the Scorpions, firstly to myself, requesting the original docket, and then the original document, Then I informed them I'm not in possession of the original. The original is under the custody of Senior Superintendent Bester. Then Senior Sup Bester received a similar communication to ask for the document, and it was said it might be used in criminal proceedings and all that. And then Commissioner De Beer wrote a letter to Gary Nel, who was with the DSO then. Commissioner De Beer informed him that he will deal with the matter. So then these analyses, once they were finalized, Commissioner De Beer asked me to accompany him to the office of Advocate Leonard McCarthy. Then the analyses were given to Advocate Leonard McCarthy. And we accepted that he will further deal with the matter. And that is why the document was not sent. When it was asked for originally, it was not just sent off because these analyses were being done.
Thanks for that explanation. So in relation to, we may as well just jump to it since you've dealt with it. And at 28.5, you've already indicated that you did fax a copy on the 20th of August 2007. But Ackerman, as you can see from 28.5, he responded saying, he would like the original document delivered to his office by no later than 1600 on the same day. Now, you've already explained that that was in possession of Louis Bester, and as you can see from 28.6, the original was apparently handed over to the Forensic Science Lab on the 22nd of August 2007. You mentioned Leonard McCarthy. If we turn the page, you'll see that Ackerman does write to Leonard McCarthy, head of the DSO, on 27 September 2007, complaining that he has still not been furnished with the original document. And that communication is at page 145 of the cross bundle. So it was a question, why was the original not provided to the NPA? And as I understand it, you've explained that the reports from the forensic experts were provided to Leonard McCarthy, and that's where matters were left for McCarthy to then handle.
That's right, and what's interesting from page 145 is what Advocate Ackerman said. Furthermore, it's important in paragraph 4 to note that the handwriting, I'm of the view, in paragraph 3, I am of the view that you do not need a handwriting expert to establish that fact.
Well, I don't want to get into a legal debate,
No,
but there actually is case law that says that the view of a handwriting expert is not decisive in these matters, and that.
I accept it can be disputed, but then also with expert evidence.
Well, in fact, the case law says that courts are entitled to consider, but not be directed by the forensic evidence, and that they're entitled to use their own, applying their own minds to the matter. But we can leave that for argument. But let me put Advocate Ackerman's complaint, and that is that he and the NPA were never furnished with the original, which meant that they couldn't do their own forensic examination. And the complaint is that that was done purposely to stop them from doing a forensic examination.
I cannot agree with that, because when the matter was left in the hands of Advocate Leonard McCarthy, he could have asked us to have another analysis being done. Even if it would have been with an analyst from the SAPS side, together with an analyst decided by the NPA, I can see no reason why that would have not have been done. But there was no such request.
Well, I don't think that's good enough, because you had received a request from Advocate Ackerman for the original. Now, Leonard McCarthy as the head of the DSO. The PCLU fell under the NDPP at the NPA.
That is correct, but the DSO was charged with that investigation.
But then why simply not give the original to the NPA because they had requested it?
As I've said, that was the route that General De Beer followed, to inform them, and they said they will deal with the matter, and whatever they needed from us, they could have requested it.
Doctor, I remember inquiring about the original. What happened to the original? Where did it end up?
Commissioner, that original document is still in Versaghi Street 28, and the evidence leaders are aware of that.
Yes, but it seems there was a denial to Advocate Ackerman to have the original, whatever obstacles may have been on the way. How can he now even invoke the assistance of his own expert, because he can't work on the duplicate which he disputes is a forged document? You agree?
I agree with that, Commissioner.
Yes. Okay, thank you.
Dr. Jacobs, when you faxed a copy of the document on the 20th of August, it was an incomplete copy. Why was that?
I understand that an incomplete copy has been received by Advocate Ackerman. It seemed to me he realized that some 20 years after the incident happened in terms of his evidence, but I can only accept that there must have been something that has gone wrong with the faxing of the document. At the time, Advocate Ackerman did not revert to me and said that he received an incomplete document. So I was not aware that only 2 pages of the document was received by Advocate Ackerman.
Yes. Well, from his perspective, he was expecting not only a complete copy, but the original at some point, and that never transpired. But let's move on, and I want to pose the question that's in 28.4 on page 11. Now, why would Ackerman write such a memo in June of 2006? And Commissioners, we did provide an English translation, which was annexed as A, and the Afrikaans version as B. And we've highlighted where Ackerman alleges the forgery took place. So the question, Dr. Jacobs, is why would he write such a memo in June of 2006 when in 2004 he had already concluded that no case had been made out against the ANC leadership, and the then NDPP Belani and Guka had released a press statement on 15 May 2004 noting that there was no basis upon which to move against the ANC leadership?
I would not know why Advocate Ackerman would have done that.
But you accept it's unusual?
It can be unusual, yeah.
Well, then, let's turn then to questions in paragraph 29, and let's move to 29.2. You've highlighted the 2 forensic investigations. Now, we suggest that those 2 investigations were not truly independent. The first one was carried out by a police officer, And although an independent investigator was also appointed, Mr. J.F. Hutting, he also served in the police from 1981 to 2006. What's your response?
Chairperson, I think from a court perspective, it's very important to realize the position of a forensic analyst. If they are once discredited in court, their career is over. Then with Brigadier Hutting, if you would look at his CV on page 1788 of the Jacobs bundle, and also excuse me, I'm just on a page there. Chair, he was very well experienced. He had international exposure. He received training with various institutions internationally. He even went to Taiwan, where he actually received training regarding the analysis of Mandarin documents. He drafted manuals for the University of South Africa. He testified in courts in our neighboring countries, as well in South Africa, higher and lower courts. He was very well experienced. And really, I can't think that for a case that comes from the police service, that a person like that would actually sacrifice his career to just simply do what he's asked to do, or to give a result that is wanted. So in my view, I think especially Mr. Hutting really had a good standing to do this analysis. And he was independent, because he was not at that stage in the police service anymore.
So while we're on the Hutting document, let's just focus on the second page, 1789, paragraph 3. He says he was requested to compare the signature on page 3 of the disputed document with the specimen signatures, as mentioned in paragraphs 2.2 and 2.3, to determine if the paper used on the 3 pages of the disputed document are the same, and if the 3 pages form one document as a whole. Thirdly, to determine whether any amendments or tampering exists on the disputed document. And then lastly, to compare the inks used on the disputed document regarding the signature, the date, and the correction in paragraph 4 on page 3. So we'll come back to that in a moment. If I can draw your attention to the subparagraphs on page 13, 29.3, because we want to point out some discrepancies to you. And let's start at 29.31. So according to Advocate Ackerman, his file notes were referenced in numerical order. The first memo was referenced A1. Memo A15, which is in our view the forged memo, was purportedly written on 26 June 2006. And memo A16, which follows A15, is also dated 26 June 2006. And indeed, memos A1 to 16 all carry that same date. However, notwithstanding the sequence, memo A17 is dated 11 July 2003, and the subsequent memos are all dated between 11 July 2003 and 10 October 2003. Is that not a discrepancy that should have alerted yourself and the others examining these documents
Chair, in law, they say, nemo judex in sua causa. I mean, this has been questioned. I'm not going to investigate myself. I'm not an investigator. And these discrepancies were pointed out, some of them in correspondence with Advocate Leonard McCarthy. So a lot of these things, even if we go lower down, the telephone numbers, all that, those are not issues that I've been aware of, that Tia Pretorius, or Tia Pena, that she didn't work anymore at the NPA and all at the PCLU. So all these issues, and even the last paragraph, the marked differences between the two handwritten sixes contained in the date, and the last 6 on page 3 of the forged document, I would not be able to say that is not the handwriting of Advocate Ackerman.
Well, given that we are alleging that that the document in question is a forgery, we simply have to deal with these discrepancies. Yeah. So let's turn to the next one. The memos A1 to A16 are all dated 26 June 2006, as we mentioned, and are all addressed to Advocate Ramaite, whereas A17 to A73 are all from 2003, and are only file notes, which are not addressed to anyone. Again, did that not raise an alarm, or should have raised an alarm looking back?
It did not raise an alarm with me.
Well, then I have to ask the question, why not?
Because I haven't looked at it from that perspective. We were dealing with a specific document at the time. I didn't go through the whole file and see how it relates to all the other documents.
Yes, but Dr. Jacobs, not addressed to anyone else to whom it may concern, aanbiedend ook al mag behaag in Afrikaans. It's a bit unusual, particularly with people who are investigating forensic. It's a bit unusual. It should attract attention. Whose attention is invited?
Chairperson, Commissioner, I once again, I want to say that I was not asked to, there was an investigator appointed to deal with the document. These issues could also be taken into account by the investigator. I was not in charge of the investigation. That was asked by General De Beer to Louis Bester to have those things done.
Yes, thank you.
Thank you, Chair.
Thank you, Commissioner. Now, on the Commissioner's point, I must also put it to you, Dr. Jacobs, that the case law actually says you mustn't investigate and look at an individual forgery or alleged forgery in isolation. It has to be looked in a more comprehensive matter, in a holistic matter, and you have to look at a range of other factors, not simply at the document itself. Is that not what the investigators should have done? And it appears that they didn't do so in this case.
I think it would have been better if the investigator did that, yes.
Yes, well, on that we agree. And then 29.3.3, and now we're talking about the context and content. So none of the memos A1 to A16 reflect any recent developments or need for further investigations, which would have caused Ackerman to suddenly knock off 16 memos in one day on 26 June 2006, because these were all matters that had been dealt with as far back as 2003.
That's correct.
And then you raise the telephone number. It's another glaring discrepancy. The telephone number reflected on the memo, 845-6432, that was the number in use in 2003. And we've put up an example of a 2003 document in the cross bundle, page 142. Although we don't need to go there unless you wish to. Whereas Ackerman's telephone number since at least 16 May 2006 was 012-845-6474. And again, we've put up an example of that. It's in the cross bundle at 143 to 144. And there are other examples. And yet, on a document purporting to be in June 2006, a number from 2003 is reflected. Is that also not unusual?
Chairperson, I think I should just point out that when these documents went for analysis, I understood that that whole bundle of original documents from A1 to A30 were submitted to the forensic analyst.
Well, then the question is, did they fail to look into that? How did they miss that?
I cannot explain that.
And then let's turn to the initials of the typist, which are reflected as TP. Now, the secretary who worked for the PCLU in 2003 was a Ms. Tia Pina. She was no longer in the employ of the NPA when the 26 June 2006 memo was typed, and yet her initials appear at the bottom of the 2006 memos, despite the fact that she wasn't there. And I think we should go to her affidavit, which is at page 23 of the cross bundle, because we approached Ms. Tia Pina, and she made out an affidavit which is dated the 14th of May 2026. And I'll just read into the record paragraphs 3 to 5. During the period 1 June 2003 to 30 September 2003, I worked for Advocate Anton Ackerman SC in the PCLU. I confirm that the official typing that I did for Ackerman in the scope of my employment with the PCLU was marked with my initials TP. Paragraph 4. I left the employ of the NPA at the end of September 2003 and stopped rendering typist services to Ackerman SC and the PCLU. Paragraph 5. I did not render any typist services to Ackerman SC or the PCLU after 30 September 2003, including June 2006. And yet her initials appear, and it doesn't seem as if the investigators looked into that aspect.
I agree with that.
And then lastly, Advocate Ackerman says that there are marked differences between the first two handwritten sixes contained in the date on the last page, on the signature page of that document, which is dated 26/6/2006. So there are 3 sixes there. And he says that there's a marked difference with the last 6 on page 3 of that document. And yet the investigators didn't find that as an issue or a problem to look into.
Chair, I can assume regarding the 6s that the paper was the same paper used. The handwriting or the signature was the same. It seemed to me that only the last 6 is disputed. Now, to get that last 6 there from a document that is dated 2003, you will have to erase the 3, or you will have to make some change to the document. To change a 3 to a 6 would not be very easy. To erase it, it would have been it would have been seen through with the microscopic and other evidence, ultraviolet and all those issues. So to me that, I can't explain, I'm not an expert in that regard, but I think that is an issue that really lies with the forensic analyst and that I can't.
Yes, which is why it was most unfortunate that the original was not supplied to the NPA when asked for it.
Mr. Vani, I understand that you have to go through this exercise. I'm not so sure that beyond clearing Mr. Ackerman's name, what else is the purpose of this exercise? If there is a good purpose, and I would assume there may be, where is Mr. Hartung, who should be carrying the can?
Well, firstly, Commissioner, we've now dealt with the discrepancies, so we don't have to revisit those. There are a couple of other aspects that we would like to canvass with this witness, which are on page 14 of the application. And we think it is important because Dr. Jacobs persists in saying that the document wasn't forged. Thank you.
Yes, I follow. I thought perhaps you should have made your point, because I don't know what would be the worth of examining a document without the original. I think the whole substratum is removed, taken from the feet of the examiner. But in any event, I don't say you must not pursue it. I just want to clear my own mind.
Yes, well, we will keep it as brief as we can, and we are quite close to the end, Commissioner.
Yes.
Let's move on to the next question, Dr. Jacobs. As far as you know, the leaking of the alleged forged memorandum to report journalist Sonia Carstens, which then resulted in this article of 18 August 2007, and this then, of course, triggered this big controversy. Was that leak ever investigated?
Chairperson, firstly, no document was referred to in that media statement. In Afrikaans, it's written, rapport verneem dat, and then give that related to the ANC 37. So there was no reference to a document as such. Furthermore, the report article was dated 19 August, not 18 August, 19 August 2007. I think you have copies of the newspaper report in your bundle. I'll just remember quickly which page it is.
It's 1769.
And I think in the cross-examination bundle, there's also an English version that has been provided.
But then, can I ask you, Dr. Jacobs, when Advocate Ackerman communicated with you on the 20th of August, following the publication of the article in Report, and he asked you to fax the document in question, the impugned document is the one that you faxed to him.
Yeah, the fact is that from the report article, it is clearly related to the ANC 37. I assumed that is the document that he was looking for.
Yes. Well,
I can't remember how he described the document or whatever, whether he gave me a file number or what, but I was able to access the document.
well, I think we can assume that the reporter, Sonia Carstens, had either access to the document or the information in that document, because that was the basis of her article.
Well, she must have received information, whether it was a document or someone who phoned her or whatever happened. I assume also she must have received an indication of the information that she was dealing with.
Yes. Well, just looking at the English translation,
Now you will see in the English translation, and that's not my translation, I think it's one from the internet, they refer in that sentence to, there's a strange word in front of Ackerman.
Yes,
I don't want to say it.
let me read the translation, and you can tell us whether it's accurate or not. And this is at page 43 of the application, sorry, page 381, the red number in the cross bundle, and it's the second line.
I have it, thanks.
Okay, and the Afrikaans version is in your bundle at 1769. But the English translation reads as follows. Report this week from impeccable sources learned that the police dockets that 2 retired police officers have made earlier, for years locked up at the headquarters of the police detective services. In the next line, the sources' names are withheld at the request because of the sensitive positions that they hold. So we won't know whether the sources are impeccable or not, but they do refer to police documentation.
That's correct.
Yes. So it does seem that police information and potentially the document itself did reach the hands of a journalist. Was that ever investigated?
No, not that I know of. I'm not aware of any complaint in that regard or investigation.
Yes. Should it have been investigated?
It could have. If the complaint was made, it could have been investigated.
Now, why did nobody in SAPS seek an interview with Advocate Ackerman to get his explanation as to why he thought the document was a forgery?
Chairperson, I can't speak on behalf of the investigator. I was not an investigator.
Okay.
And I must say, if I read that question, whether I had any knowledge about the leaking of the forged document, I can just say I have no knowledge of that.
Thank you. And we don't doubt that, at least Dr. Perhaps if we can just go back to that English translation, because my attorney has just pointed out another passage which suggests that they probably did have the document. And that's towards the bottom of the page. It's like the 4th paragraph from the bottom. And I'll just read it into the record. And again, this is at page 381 of the cross bundle. Ackerman had earlier instructed in writing that the police have evidence in the investigation of the ANC leaders, have gathered a view to possible prosecution. But last week the police refused to say whether the assignment is carried out and the progress. We just highlight the words Ackerman had earlier instructed in writing. So it does seem to suggest that perhaps the document was in the possession of the journalist.
I'm in agreement with that, Chair.
Yeah. So we just want to put it to you that, you know, if the remit to the forensic investigators had been wider, and not just in relation to the signature, the paper, the ink, and alterations on the document itself, but if they looked at the sequencing, the difference in dates, the content of those documents, the phone number and the initials of the typist, do you think they might have reached a different conclusion?
Yes, Chairperson.
So then the question is, why were they not given that wider remit?
I can't answer that. I was not the investigator, Chair.
Yes, really, Mr. Bani, that's unfair.
Yes. We won't...
He's not in the mind of those people. So.
Yes, indeed. Well, just to wrap up this section, we just want to put to you some statements for your response. We want to put it to you that, and here this is not an accusation against you yourself, but that in this investigation, SAPS failed to apply their minds and they considered the impugned document in isolation. They relied exclusively on handwriting experts without looking at the wider context.
Chairperson, the SAPS leadership, I can't talk on their behalf on the issue of failing to apply their mind, etc. As I've said, the investigator should have or could have looked at those issues.
And we also want to put it to you that the document in question was forged. It was manifestly altered by elements within SAPS. And we believe this was done in order to place pressure on the government and the NDPP to remove Ackerman from the TRC cases and ultimately to bring an end to the TRC prosecutions against all sides in the conflict.
Chairperson, I have no knowledge of that.
Okay. We want to turn to one last matter. You raised the Highgate Hotel matter in one of the task team meetings in January of 2007. This is at PCJ 11. And you mentioned that the Highgate Hotel matter did not require further investigation. That's at page 1753. Now, the Highgate Hotel massacre inquest actually wrapped up in December last year. And one of the findings made by the inquest court that the likely culprits had been engaged in a false flag operation. Can you explain why in January of 2007 you took the view that no further investigations were necessary?
Chairperson, the docket on the Highgate matter was requested by the PCLU. So I got hold of the docket through Brigadier McLaren, Director McLaren. And I studied the document before I gave it to the NPA. And if you look at the place where Advocate Maga signed for that document, it is page 1768 of the Jacobs bundle. You will see it was there were two ring binders, evidence A1 to 80, correspondence B1 to 89, investigation diary C2 please see 153. There were also color photographs, 102 of them. And when I read the docket, there were already affidavits referring to the issue that it was not APLA, or that it was rogue elements or something. I can't remember exactly. But that allegation was already in the docket. So the reason why I read it was just to see whether the docket looks in order to hand it over to the PCLU. And the PCLU are the people who will decide further on how they will deal with the matter. So that docket had been with the PCLU since that date, the 29th of January 2007.
Thank you, Dr. Jacobs. No further questions, Chairperson.
Thank you. Mr. Soni?
There is no re-examination, Chairperson.
Thank you. Dr. Jacobs, we again thank you for having come to give evidence before this commission. You are now finally excused as a witness.
Thank you, Chair.
Thank you. These proceedings are adjourned until tomorrow at 10 o'clock.